105643 James Becker and the estate of Norman Becker v. Harold Knoll.
Mr. Chief Justice, this is Jerry Schultz from Garden City for Harold Knoll, the petitioner for review. I'd like to reserve 5 minutes for rebuttal.
5 minutes is granted.
May it please the court. Practiced law for a while in Western Kansas. You ask yourself, why would the court take up this petition for review? And I think the answer is that the Court of Appeals in this case used the wrong focus, that is, the wrong standard of review. This case has a history to it, and I'll briefly go through it. The case was filed in 2004, tried in 2008, Court of Appeals decision, then petitioned to this court, and we have what I refer to as Supreme Court 1, Becker versus Knoll, describing that the Court of Appeals erred in using the wrong standard and also told the district court to follow the correct shifting of the presumption once a prima facie case was made, and the mandate was sent back to the district court, the Honorable Philip View presiding. The district court, according to the petition for review and Mr. Knoll, I submit to the court, correctly followed the mandate of this court in that it found that the plaintiffs had made a prima facie case. That was an error the first time around. So the district court opinion is critically important for the purposes of my argument today as to what the trial court did. This court said that once the plaintiff makes a prima facie case, then the burden of proof shifts to the fiduciary, the corporate director or officer, to prove by clear and convincing evidence that there was no defalcation of the duty. It does not say that there has to be a certain type or kind of evidence, just that there needs to be highly probable evidence produced to overcome the prima facie case. In this case, paragraph 1 of the trial court's decision correctly states your holding, which is once the plaintiff proves a prima facie case that there was evidence of a breach of the fiduciary duty at trial, the burden of proof shifts to the defendant, director or officer, to prove by evidence that's highly probable that they did not breach this duty or cause the damage. Once the trial court has correctly applied the law, then the issue becomes, was there evidence to support the trial court's decision that the rebuttal by the defendant, my client, Mr. Knoll, the evidence was highly probable. This again is, in no doubt, a function of the trial court. It is respectfully suggested that the Court of Appeals erred in this case by taking a de novo or unlimited review of the second trial court decision. And this was error, and here's why. The trial court correctly shifted the burden of proof, put the burden of proof on the defendant to overcome the prima facie evidence case, and the court made detailed findings based on that evidence that the defendant succeeded and found generally for the defendant again. So the interesting part of this case is how could we go wrong again? And at oral argument before the Court of Appeals 2, learned counsel from Cimarron and I had a colorful debate before the panel of the Court of Appeals at that time. One of the things that this court said in Becker versus Knoll 1 at the Supreme Court level was that there was a comment made at the end of the opinion that, as an aside, you felt that it would be hard for the defendant to prevail given the lack of time records for the ditch rider. The ditch rider's name is of Mr. Morehouse, and he's a simple man.
It's I guess the question is it irrefutable evidence? There's no question that Mr. Knoll did not keep time records for Mr. Morehouse as was required by the bylaws of the corporation. Isn't that right?
That's what the evidence suggests at the trial court.
And so, tell me how you overcome that requirement by the bylaws to keep those records. In that, then Morehouse worked. I believe he's required to work at least 40 hours a week in his capacity. And explain how you can show that, or how that was shown to the district court.
I think that there are lots of duties in bylaws on officers that can be overcome by their simple and plain testimony. The requirement to keep records is a duty to the corporation. I don't dispute that. That's one of the fun parts about not being trial counsel and only being appellate counsel is you don't have to worry about what I could have, should have, would have, might have done, but rather what was done.
Right.
And there would have been a lot of different ways for both the plaintiff in the prima facie case and the officer to prove the amount of time worked. Timesheets alone is almost requiring a certain type or kind of evidence to prove a fact. And I don't think that Kansas evidentiary law requires a certain type or kind of evidence. Instead, I think that given that the statement of this court that it would be hard to do that, required the district court to find that Mr. Morehouse and Mr. Knoll's testimony was highly probable. Because I think the most gruesome fact in Kansas of a heinous crime can be proven solely by the testimony of one witness. And we don't have to have corroboration of that witness's testimony in a rape case. We don't have to have written documents to test the probability of truthfulness of that one witness. To require a certain type or kind of evidence is really to rewrite, in my opinion, evidentiary law in Kansas. And the criminal case has a much higher standard of proof. Yes, this is a higher standard of proof than a preponderance of the evidence, but it is not a fact that has to be proven beyond a reasonable doubt, nor does it need to be tested.
Sounds to me like you're making an argument with several steps of analysis, and let me see if I can break it down and see if I got it right. That it sounds as if you were admitting that there was a breach of fiduciary duty in the failure to abide by the bylaws, but your second argument would be that that resulted in no harm to the shareholders if it can be established that the purpose of the bylaw was met, which would be step number 3, and that purpose would be that there is the employee was being utilized the way the shareholders expected, the full 40 hours. And step number 4 is the alternative proof. Is that fair?
No, I don't admit that there was a breach of the duty on behalf of Mr. Knoll. In fact, I think it's to the contrary. But I think the plaintiffs proved a prima facie case that a rational fact finder could find that he breached his fiduciary duty. Then the burden of proof shifts to Mr. Knoll to show that there was not a breach of that duty by clear and convincing evidence.
And so explain to me why there was no breach. You don't believe there was a fiduciary duty to abide by the bylaw?
I think the bylaw is incidental to the theory of the plaintiff's case, which is that they used Mr. Morehead for Mr. Knoll's personal use on company time. That's the breach that they're trying to prove. I don't think they're trying to prove that failure to use time records is a breach of a fiduciary duty to the corporation. Instead, I think they were proving, and the theory of the case tried below was that there was a breach of duty by utilizing the company employee on company time. And so it's a matter of proof as to whether there was time records or not. not that there was a breach of the duty by the failure of the record, but rather breach of the duty by using the employee for your own personal gain. That was their theory below. So therefore, the analysis from there is that I would go to the alternative theory, but first there was not a breach, but there was a prima facie case shown at the trial court. Secondly, then the defendant, Mr. Knoll, proved by highly probable evidence that there was not a breach because both he and Mr. Morehouse's testimony were clear on the subject. And that's what the trial court found, and found generally in favor of Mr. Knoll. Now, it is also correct that I didn't seek to have any corrections to Mr. Ridenour's brief with regard to the testimony that he attached, but that's really all that he has left because of the failure of the Court of Appeals to use the correct standard. If the Court of Appeals had used the correct standard on this appeal in Court of Appeals 2, the only inquiry from the Court of Appeals was, did the judge shift the burden of proof correctly? The answer, yes. That's the issue of law that they have unlimited review on. Then the issue of, was there evidence highly probable to overcome the prima facie case, would have been a review standard of substantial competent evidence, which I suggest is the correct standard in this case.
Say that again, please.
Once the trial court used
The last step, when you started to introduce substantial competent evidence into your analysis.
Okay, the substantial competent evidence test is the correct standard of review in this case. And the Court of Appeals missed the mark.
Substantial competent evidence to support the factual findings made by the court.
The trial court, yes, sir.
Okay. And that is the same standard, is it not, just for preponderance of the evidence?
It is, but in this burden shifting case, the evidence had to be substantial competent evidence that is highly probable.
That's what I want you to focus on, the highly probable nature.
All right. Highly probable evidence is that which would, as in paragraph 2, Judge View at the trial court said, evidence that's clear and convincing, clear and satisfactory. That quality of evidence is a methodology by which the trial judge requires more than just a preponderance of the evidence. And the difference between preponderance and clear and convincing and proof beyond a reasonable doubt is probably one of those things that Justice Potter Stewart said one time, I don't know how to describe it, I just know it when I see it. And I think that's what a trial judge has to do. That's the standard that we want to use. If it's a preponderance, it's just merely a preponderance. If it's clear and convincing, the evidence needs to be clear and convincing to an objective person who observed the people testify. I think that is the deference that must be given to the trial judge. And when you put the right focus on, even though that he found only a preponderance of the evidence the first time, the second time the decision attached to the petition for review elevated the standard of proof on the defendant's part, the defendant still prevailed. So what evidence was highly probable? I submit to the court that a simple man who's a ditch rider who testifies clearly and succinctly that I worked my 40 hours before I ever did anything for Mr. Knoll is highly probable. A person ought to be able to testify in our Kansas courts, that's what I did. If you have evidence to the contrary, the burden of proof is on you. But a person should not have to be required to create a certain type or kind of evidence to test the believability of the ditch rider's testimony. Or of Mr. Knowles, who was the president and also a farmer, who testified clearly that Mr. Moorhead always worked his 40 hours before doing any work for Mr. Knoll. If believable, and believable to the level of being highly probable, no further testimony should be required. It is an artificial evidentiary standard to think that a person can't testify clearly about a fact and issue, and that evidence can't be ever clear and convincing unless it is tested. That's unique to the law. There are certain types and kinds of cases where we have to have certain types and kinds of evidence, such as a medical malpractice case. I think we're going to hear about one of those today. You have to have an expert opinion as to causation. It's the law. in new scientific matters. You have to have you have to pass the Fry test. This is not one of those cases. This is a case.
It was tested by cross-examination, wasn't it? I mean, Mr. Morehouse was subject to cross-examination based upon his recollection of his work.
Yes, sir.
Yeah, and that was part of the calculus that the trial court entered into when he made his determination as to whether it was credible or highly probable and credible.
I would agree. And that is the function of the trial court in this case. Thus, to wind it up, the Court of Appeals 2 decision used the wrong standard. They say in their opinion that our review is unlimited. When they used the unlimited or de novo review, they used the wrong standard of review, and then their focus was to draw negative inferences or inferences that they saw out of the evidence. If they had only used the substantial competent evidence test that's highly probable in this burden shifting case, the outcome likely would be different.
And therefore, what are you asking us to do?
I'm asking you to reverse the Court of Appeals' decision using the wrong standard, and then review the record with the correct standard and direct this case back to the trial court, that the trial court's judgment be sustained.
All right, thank you. Any more questions? Thank you, counsel.
Thank you.
May it please, excuse me, may it please the court, I'm Phil Ridenour. I'm the lawyer for the plaintiff appellee shareholders, James Becker, who is seated at counsel table with me, and his father's estate, the estate of Norman Becker, deceased.
Excuse me, counsel, I hate to interrupt what you're about to start. You may be aware that our rule is that only lawyers licensed to practice in Kansas before this court are eligible to sit before the bar.
I'm sorry, I beg your pardon. James, if you don't mind, just...
No
I beg your
problem.
pardon,
I
sorry.
thought maybe he was a New York City lawyer you'd brought in to assist on the case, and he was admitted pro hoc vice. No problem at all. Please
I
continue.
apologize. This case, excuse me, this case has previously been before this court on one occasion. This is its second appearance here, and it's previously been before the Court of Appeals on 2 separate times. So why are we here today? We're here today because the ditch company president used the ditch company employee to work on the ditch company president's personal farm while he was being paid by the ditch company. We're
Mr.
here
Reitner?
because, pardon me?
Mr. Reitner, I'd like to hear right away your response to your opposing counsel's argument that your case isn't about any violation of a bylaw rule that time records have to be kept, that it's about the work that was performed on this gentleman's land rather than for the corporation. Do you agree with his characterization of what your case is about?
I think our case is about 2 things. It's first of all the disregard of the corporate bylaw and the failure to maintain records, which we've already gone into. And it's also then about the ditch company's president's use of the corporate employee when he was being paid by the ditch company to work for the ditch company. And I think the best analysis of where we think the trial court went wrong is, according to the trial court, if the employee was hired by the ditch company to work 40 hours a week, and he worked 20 hours a week for the ditch company, on ditch company business, and he worked the other 20 hours a week for the president on the president's private farm, then in the analysis of the trial court, that was just fine as long as the ditches were properly maintained. Because the trial court did not follow this court's ruling that to rebut our case, the president needed to prove the case, needed to prove that he acted in good faith and in substantial fairness to the corporation. The trial court instead changed that test to be that as long as the ditches were properly maintained, then it didn't make any difference if the employee worked 20 hours, 10 hours, 5 hours, because the ditches were properly maintained was a substitute test for the test of fairness.
There was a finding by the district court that Morehouse worked the requisite hours that he was demanded by the contract to engage in the clearing of the ditches. Isn't that what the district court found?
Yes, but yes, it did find that, and that was an impossible.
And why? And how is that? And how was it not found by clear and convincing evidence? I think the trial court went to extraordinary lengths to articulate his determination and say it met the standard that was required by us that had to be met. Where did he go wrong?
He went wrong because in this court's opinion, in the BDY case, to determine something by clear and convincing evidence, the trial court must be satisfied that the evidence presented was highly probable.
And he said it was.
He said it was.
He
Yes,
heard
did.
the evidence, heard from two different witnesses, and had heard this case before, heard the evidence here, and made that specific finding.
That's exactly right. I agree with that. Where the Court of Appeals disagreed with that decision was it looked at highly probable. And was it highly probable evidence, which if I understand it from this court's ruling in BDY, that's the job of the appellate court, is not to weigh the evidence on appeal. It's to look at it and determine if a rational fact finder could have concluded that the evidence was highly probable. And in this case, what we had, instead of highly probable evidence, we had Mr. Knoll, the defendant, standing up basically and saying, I didn't do anything wrong. There's no lawyer in this courtroom that would agree that if Bernie Madoff stands up and says, I didn't do anything wrong, that's clear and convincing evidence. Clear and convincing evidence is judged against the standard of whether it's highly probably true.
Well, what he did wrong was he didn't keep time records.
What he did wrong was he didn't keep time records, and he used the employee to work on his own farm.
And the lack of keeping time records, I think you basically conclude that it's a non-rebuttable presumption.
I agree with that.
That's basically your position.
That's exactly
is that
right.
The failure to keep time record creates a non-rebuttable presumption. Is that your position?
That's one of my positions. The other one is that the trial court's invented test of properly proved or properly cared for ditch was the wrong standard. And my third one is there's absolutely no finding, no reference, no mention, no comment in the trial court opinion about fairness and good faith. You sent this case back to the trial court to find that there had been that Mr. Knoll had acted in fairness and good faith to the ditch company. There was no finding of that by the trial court. Trial court opinion does not mention fairness or good faith ever.
But it references accuracy. On paragraph 6 of the court's order, the court talks about Morehouse's testimony at trial that he, quote, always put in a full week for the corporation, and when water was in the system, put in even longer hours. And the court went on to say that taking into account his testimony and all of the other evidence and testimony at trial, this appeared to be truthful and as accurate as he could be, he being Morehouse.
I agree, Your Honor. That's exactly what the trial court said. But we're
I
back.
don't understand how that finding means the court was saying it was okay to work 20 hours. The court's finding that it was accurate when Morehouse said he put in a full week for the district, and even longer when water was in the ditch.
Well, two thoughts. First of all, I think we're back to headnote 4 of the BDY case. It says, on appeal, it's the duty of the appellate court to determine whether a rational fact finder could determine that the evidence presented was highly probably true. So that's different from weighing the evidence. And to me, that's an entirely different concept than the de novo review. And it's not weighing evidence, it's just simply looking to see, could a rational fact finder find that the evidence presented was highly probably true? The answer then, to finish my comment, is to look at Morehouse's testimony that's represented in that's referenced in our briefs, and it's also referenced in some of the exhibits to our briefs, indicate that there are some real questions about whether Mr. Morehouse was truthful or not. It's the same as Mr. Knoll's comments are undercut by his failure to maintain records. Is it highly probably true And that's different from weighing the evidence, and it's a requirement that the evidence be highly probably true in order to establish the evidence, the case, the facts by clear and convincing evidence.
Counsel, I'd like to just, if we can, separate in our mind for a moment the allegation that Mr. Knoll engaged in behavior that violated his duties to the corporation by employing this person on his property, or by letting this person work on his property for money the corporation was paying. Put that aside for just a minute, and let's focus again on this bylaws provision. If that were your only claim, do you have to demonstrate some kind of damages to the corporation to maintain that claim?
Well, I think I guess we're back to the question, if he can't demonstrate how many hours that he worked for the corporation, and he can't because he doesn't have any records, the burden of proof is on him to prove he didn't.
Let me understand again. I'm just back up one more step for me, if you will. The bylaws require keeping of time records.
Yes,
Okay.
Your Honor.
So the violation there is the failure to keep the records, not the use of the gentleman to work on his property.
I agree with that.
So if we assume that's all correct, then in order to maintain an action for that violation, does your client have to demonstrate there are actually damages flowing from that violation?
Yes, I believe so, and on the damage issue, we presented quite a bit of evidence on that in the trial court as to the
Tied
damage.
to that
as to the-
violation?
See,
Tied to that violation as opposed to the other one?
Oh, as to the failure to maintain records by
Right.
itself.
Did it give rise to
no,
damages independent of the other?
No, I don't know that the ditch company or the shareholders would have been damaged by simply the failure to maintain records.
Okay, thank you.
I don't know that we would have been.
Usually when we apply the appellate review and looking at the evidence, we look at the light and the most favorable of a certain party.
I agree.
In this case of shifting burdens, how do we apply that? Who are we giving that favor to?
Okay, the burden of proof is on the burden of proof is on the defendant Knoll to prove by clear and convincing evidence, judged by a rational fact finder to be highly probably true, that he did not use the employee to work on corporate time. All right. That burden of proof is on him. Upon appellate review, it's the party that has the evidence is looked at in the light most favorable to the party that has the burden, which in this case would be defendant Knoll. So upon review, then the Court of Appeals properly said that we're going to look at the evidence in the light most favorable to defendant Knoll in looking to see whether he proved by clear and convincing evidence that a rational fact finder would find highly probably true. I'd like to look at President Knoll's argument from three standpoints about the standard of review. The first of those is the impossibility of rebuttal. The second one is the trial court's improperly invented test to determine whether the ditches were properly maintained. And the third is the total absence of a finding of good faith and fairness as required by this court. Let's look first at the impossibility of rebuttal. Under the facts of this case and the prior ruling of this court, it's absolutely impossible for the president to rebut the shareholder's prima facie case.
Do you have a case where there's absolutely non-rebuttable evidence that can't be refuted or rebutted in any way? Do you have a case that wherever we've held that there's
No.
that kind of evidence that exists that it can't be rebutted?
No, sir, I believe this case is the very first case I've ever seen that had that.
We didn't say that.
Your Honor, I would respectfully disagree with that.
All right.
This court previously held, and I quote, under a proper allocation of the burden of proof, the plaintiffs would not be required to show that Morehouse did not work his required hours. Rather, Knoll would be required to present evidence showing that Morehouse actually worked his required hours. If, as Knoll maintains, there were no fixed employment hours for the ditch rider, then it would be impossible in any event to determine which hours Morehouse worked for Knoll on corporate time. End of quote. For 3 years, the president violated a bylaw of this ditch company requiring him to maintain a record of his use of the employee, and he totally neglected that duty, and that's the exact reason this case is before this court at this time. As a result of the defendant's failure to maintain the required records, it's impossible for him to present evidence showing that the hours that the employee worked on the defendant's personal farm and the hours that he worked for the corporation. Because it's impossible for him, under the facts of this case and the prior ruling of this court, to show the hours that he worked personally, it's impossible for the defendant to carry his burden of proof to prove that the employee worked his required hours. And because he can't prove that the employee worked his required hours, there's no way that he can rebut our case.
What was the evidence on whether there were fixed hours of employment for Mr. Morehouse?
There was a great deal of testimony, Your Honor, at the trial level as to the flexibility of the hours. Some hours, I mean, some weeks it was suggested in the summer when there was water in the ditches, he'd work perhaps 80 or 90 hours a week. Sometimes in the winter, he might only work 20 or 25 hours at a time.
Well, if that's then you don't dispute that there weren't fixed employment hours for Mr. Morehouse, from what you're saying.
I don't dispute that there were no fixed hours. 40 hours was a minimum requirement. He was hired and with the understanding that he would work 40 hours a week, period. And then sometimes
Then I guess just to tell you where I'm having a problem,
Okay.
I'm reading this sentence from our last opinion in this case, and I don't see under that factual scenario that you concede how this sentence helps you.
I'm sorry.
It doesn't seem to me to be an impossible, what it seems to me to be saying is that if there aren't any fixed hours, it's going to be impossible to show that that Mr. Morehouse was actually working on corporate time because it was so flexible. That seems to be to me, that seems to be the same thing the district court was saying. Or am I wrong?
I think where I'm having the problem is that's not our burden. Our burden was not to prove that he did or did not work the hours. Our burden was to establish a prima facie case.
And I don't think I care who had the burden. Because all I care about is that the fact was established. And if Noel established it, that's fine with me. I'm just saying, what's the outcome of that determination? And it seems to me that the outcome is that it's more difficult for you then to come further with your claim. Now, where am I wrong?
I think it's a burden of proof issue, and I'm not sure I'm understanding what you're suggesting. We don't have the burden. Defendant Noel has the burden to prove that a minimum of 40 hours were worked, and he can't prove that. And under the prior holding of this case, or this court, it's impossible for him to prove that. He cannot establish that because there are no records. And that's not our burden.
And explain again why he can't prove that through other forms of evidence.
That was what was attempted through his only evidence is Morehouse, the ditch rider, and himself standing up and saying, I didn't do anything wrong. Those are his only efforts. And under the duty of review by the Court of Appeals, was that evidence highly probable evidence? And in the opinion of the Court of Appeals, no, it wasn't. It was not highly probable. A rational fact finder could not have found that evidence to be clear and convincing. On remand, the trial court ignored the order of this court that the president had to prove that he acted in fairness and in good faith, and instead it invented its own test, and that test was the properly cared for ditch. In the theory of the trial court, rather than to find the finding required by this court of fairness and good faith, The trial court invented and substituted its own test of properly cared for ditch. As long as the ditch was properly cared for, then in the opinion of the trial court, there was no self-dealing, no assertion of self-interest, no misfeasance, and no malfeasance. Nowhere in the district court's opinion on remand will you find any reference to the fact that the defendant, Knoll, proved good faith and fairness to the corporation as required by this court. Instead of following the order of the trial court simply invented its properly cared for test. Next, the absence of fairness and good faith. Again, in the trial court's opinion on remand, you will find no reference to any requirement set forth by this court that the defendant acted in fairness and good faith to the corporation. And in order to find that the president acted in fairness and good faith to the ditch company, the trial court had to find two things. Number one, that the use of the ditch company to work on the president's personal farm while he was being paid by the ditch company, and number two, that the violation of the bylaw adopted by the directors to prohibit this kind of thing were both acts undertaken in good faith by the defendant. Obviously, there was no way that the trial court could make that finding, and so it simply avoided that finding by taking the position, that it acted in good faith and fairness. In this court's opinion, this court favorably cited a New Jersey case holding that when a director acts under an incentive to disregard the corporation's interest, the director must show the utmost good faith and the most scrupulous inherent fairness of the bargain. In its opinion, this court didn't state on only one or two occasions that Mr. Knoll had to prove his good faith and fairness to the corporation. This court repeated this same statement some 8 to 10 times, both in cases cited from this jurisdiction and other jurisdictions, and in its holding that Mr. Knoll was required to prove that he acted in fairness and good faith. I'll be happy to try to answer any questions.
Counsel, it appeared as though Judge Bew made a credibility determination, at least as far as Mr. Morehouse.
He did.
And
His exact words, I'm sorry.
Well, you go ahead.
His exact words were that Mr. Morehouse was as honest as he could be.
He appeared to be truthful and as accurate as he could be.
Yes.
So if the trial court made a credibility determination about Mr. Morehouse, what are we supposed to do about that?
Look at the head note 4 to the BDY case that requires the appellate court to make a determination that the evidence was highly probably true. That's different from reweighing it. Was the evidence presented highly probably true in the minds of a rational fact finder? And the Court of Appeals concluded, no, it was not. It was not highly probable evidence that was clear and convincing. Rather, it had all of these other issues pointed out in prior briefs and transcripts of Mr. Morehouse's testimony, that there was conflicting testimony. That's different from weighing it.
Well, let me put it more particularly. Can we do anything about the fact that the trial court found Mr. Morehouse to be truthful and as accurate as he could be, i.e. credible?
The only thing we can do is, under the BDY case, conclude that it was not highly probable evidence and there was reason to believe that it was not correct.
We cannot overrule the trial court's credibility determination, can we?
No, but we can find that the evidence presented does not meet the highly probable standard that's required by BDY.
So even if Mr. Morehouse is in fact very credible, his testimony does not rise to the level of being clear and convincing evidence, is what your point is.
In the minds of a rational fact finder, yes, Your Honor.
All right.
And that's because he was incapable of knowing how many hours he worked a week?
That's part of it. Plus, he just had some other comments, Your Honor. In the trial court, he was asked the question, did you ever work for Mr. Knoll? And the transcript that's reprinted as an appendix, he said no.
Any further presentation? Any more questions? Thank you, counsel. Reserve 5 minutes for rebuttal.
Thank you. Touching on the arguments made by learned counsel, it is important for this court to reverse the Court of Appeals decision and order judgment according to the trial court's decision, because the correct legal standard for review of this appeal is, did the court properly apply the law of Becker versus Knoll as dictated by this court? If the answer is yes, then on appeal from the findings of fact made by the trial court, whether it's the Court of Appeals or this court, the test is there substantial competent evidence that is highly probable? That is the correct standard of review. And Justice Johnson, I'd like to touch on one thing that you talked about, which is, can the man testify that I always worked my 40 hours, and can that testimony alone be sufficient to prove the fact that was an issue? The fact that an issue was not the breach of the keeping the records, but rather using the employee for your own benefit. And if the employee testimony has to be supported by some other kind or type of evidence, then we're setting a whole new standard for Kansas jurisprudence. If we're setting a standard by an aside in a previous Kansas Supreme Court decision that says you have to have a certain type or kind of evidence or a presumption that can never be rebutted, that's very novel. And I don't think that's what this court was intending to do in Becker versus Knoll 1. And I think that a person ought to be able to come to court in Kansas and testify, I worked my hours. And if the judge finds his testimony to be highly probable and truthful and accurate as he could be, that's the end of the inquiry.
What does that mean, that he was as accurate as he could be?
I think it gives deference to the trial judge to be able to observe that the ditch writer wasn't a PhD in astrophysics, Your Honor. He doesn't keep a detailed time record. He does the work that needs to be done, that was assigned to him. A ditch writer in western Kansas along the irrigation ditches north of Garden City works an incredible amount of hours when there's water, trying to keep the ditch in shape. And when the ditch isn't being used because we've had 4 years of drought, preceded by 4 years of not as much water in the river as we would like, there's not a lot to do. So Mr. Morehouse was not a person who punched a time clock. He was not a person who kept a record. He was not a person who did anything other than ride the ditch, and that was his job. And when these two farmers, Mr. Knoll and Mr. Becker, started to squabble over the use of the ditch rider, it would have been really nice if the evidence at trial would have included W-2s, tax returns from both the corporation as to the amount of wages paid, all of the underlying corporate records that all of us know exist, but were not utilized by trial counsel below. And that lack of evidence is not unusual. People try cases for different reasons in different manners. Perhaps the plaintiffs were relying on the trial court to find Mr. Morehouse to be not credible, and therefore easy to prove their prima facie case, and very hard for Mr. Knoll to rebut that prima facie case by evidence that's highly probable. But here the trial judge found Mr. Morehouse to be highly credible, as credible as he can be. And can be means that that's maybe a subjective remark by the trial judge saying, I realize that he's not a highly educated man and didn't really express himself the best way that he could. That might be. But there's nothing there to suggest that he was not credible. In fact, the finding of the trial court is that he was. In fact, it was highly truthful. I don't think that it would do me much good to remind the court that you don't give advisory opinions. You didn't direct judgment in Becker versus Knoll the first time. You corrected the wrong focus, the lens, and you corrected and directed the trial court to use the correct legal standard, which it did. Having done that, the law was followed as dictated by this court. I would ask for you to affirm the trial court.
Any questions? Thank you, counsel.
Thank you.
We thank you both for your arguments this morning. The court will take this matter under advisement.